So, Matthew, the average gun owner, just a quick note here on the New Jersey quote unquote assault weapon ban case. I'm going to give you a little insight that other people may not get into. This judge clearly is off his rocker, clearly doesn't understand firearms, clearly doesn't understand the law that's applicable here, neither Heller or Bruin. I attended the first oral argument years ago when the case was first filed, and it was clear and evident to me. But he even admits in his opening paragraph here that he's interjecting his feelings over what the law says he's supposed to do. It's funny, he opens his case and says that plaintiffs challenge constitutionality of the assault firearms law, and then mentions that Cheeseman, the plaintiff Cheeseman, his arguments were more narrowly focused during argument on the AR-15. So he took that, which is of no legal significance, that it challenged all assault weapons, but focused on Cheeseman's desire to purchase AR-15 pattern rifles, to say this decision is limited to the AR-15 pattern rifle. That was a huge reversible error on the judge's part. And it's funny here. He says, it's hard to accept. Quote, I'm quoting the judge here. It is hard to accept the Supreme Court's pronouncement that certain firearms policy choices are off the table when frequently radical individuals possess and use these same firearms for evil purposes. Okay, so what? This judge is admitting he's prohibiting good people from possessing an item that's constitutionally protected because evil people out there will use it for evil purposes. That's irrelevant. The judge knows that. He states and goes on and basically whines and complains that even so, the court's decision today is dictated by stare decisis. I'm paraphrasing. That is, where the Supreme Court has set forth the law of the nation, and as a lower court, I am bound to follow it. This principle, I'm quoting the judge here, this principle, combined with the reckless inaction of our government leaders to address the mass shooting tragedy afflicting our nation, necessitates the court's decision. Complete and utter BS. This judge is clearly using his personal political beliefs and ignoring what the Supreme Court has directed him to do. He's finding that the large capacity magazine, so-called large capacity magazine ban, is constitutional and has overturned the ban as it relates only to the Colt AR-15 rifle, not even Colt pattern or AR-15 pattern. Very poorly written, horribly written, atrociously poorly written decision here from the federal court judge. The complaint obviously attacks every firearm that was listed on the state prohibited list as an assault weapon, but because arguments focused on one particular firearm type to make the point in oral argument, this judge has said, I am narrowly limiting this decision to the Colt, and only the Colt brand. In the decision he wrote, the Colt AR-15. So basically, unless you have one of the actual banned Colt AR-15s, this decision doesn't apply to any other so-called assault weapon in the state. And I haven't read the section yet on the magazines, but it's irrelevant. The judge here clearly didn't get it. He's just saying he's not granting summary judgment at this point. But obviously this is going to go up in appeal and not go to a trial at this point. He also, there were some Daubert motions that were expert testimony type motions that were denied here. So obviously there's going to be a further appeal. I think obviously the ANJRPC is going to try to get this right up to the Third Circuit Court of Appeals. There's really no reason or no need to take any further fact or scientific or expert testimony here. It's irrelevant what firearm is used by criminals in this analysis. That is not the analysis put forth by the Supreme Court. So a little bit of explanation there on this decision you may not even hear from Four Boxes and others, but clearly just from that opening paragraph alone, it is clear this judge is saying that the use of firearms by evil people is a problem in this country. Nobody disputes that. But the problem is this idiot is prohibiting the actions of good law-abiding citizens because, as he admits, the action of few evil individuals, which are going to commit evil actions with a knife, firearm, a car, blunt object, fists, anything else. It just makes no sense to me. Bathtub, you kill people with a bathtub and drown them. So it makes no sense to me. The judge clearly here just doesn't like firearms, just wanted to uphold the ban and knows he's going to get overturned, or one of the judges will eventually get overturned on these assault weapon bans, AR style bans. So he just played coy, did a little bit of mental gymnastics that clearly aren't going to be upheld. Maybe upheld in the Third Circuit because the Third Circuit likely agrees with him, except for a few judges that I know clearly won't agree with him. But you have to get a majority of judges on the panel to agree. But he's clearly just going to further restrain what he knows are your natural born rights in New Jersey. Openly and defiantly going to defy and ignore Supreme Court precedent, claims he's been bound by it, but clearly doesn't follow it, clearly puts his emotional and personal beliefs into his decision making, which is absolutely improper under any analysis under the Second Amendment today, and has continued the prohibition and has continued to deny you your basic civil rights, and has basically said, F you, go to the higher court and get them to overturn me. That's one of the major problems and frustrations that I have in practicing in the courts today. That kind of, wouldn't even say illogical, I would say it's unethical. That's just unethical and a violation of their oath to uphold the Constitution and apply the law equitably. I mean, it's just a flat out violation of their oath, and it's pretty sad to see. And more judges are doing it today. There's no way around it. I mean, we even have the current federal administration trying to pack the Supreme Court and set up new election of justices in a cycle that will favor whatever political party in the short term is in power, which mean they could further consolidate power and their control over the Supreme Court. Supreme Court is supposed to be an independent body from the legislature and from the executive branch, which is why the executive branch should have less control over the Supreme Court, which is why the appointments are lifetime that the way they are, is so that they're not beholden to political parties in the way that the president or members of Congress are, based on the whim of the voters every 2 to 4 years. That's a pure democracy. It's not what we have. We have a representative republic, and we have a Supreme Court that is a lifetime position of people that take an oath to uphold and interpret the law in a way that favors the rights of the individuals. This Supreme Court has been doing that. I know a lot of people obviously may be familiar with the Bruin decision, but may not be familiar with other decisions, such as overturning the Chevron doctrine, which basically was a doctrine that allowed the federal government to appoint somebody who knows nothing about a subject matter, but deference was given to that individual. Let me give you an example of that. And this is something the current administration is complaining about, and specifically said we need to pack the court and take control of the Supreme Court because we don't like their decisions. Go read the press release. So really quickly, look at this situation. One of the things they were complaining about was that decision on Chevron, the Chevron doctrine. Let me give you a good example of how that works. So remember just a few months ago, the director of the ATF was putting on a dog and pony show on TV, and they handed the director of the ATF a Glock and had him field strip the Glock, and he couldn't do it. The director of the ATF, who under the Chevron doctrine, before it was overturned by this current Supreme Court, would have been given deference as the be-all to end-all expert on everything firearms related, and deference would be given to whatever the ATF said, whatever they put out as their opinion would be given deference. It would be a high burden for anybody to overcome, and even if Congress didn't speak on the issue, the ATF can fill in the gaps. Yeah, know who that individual was? That was an individual who couldn't even do something as basic as stripping a simple Glock firearm. Absolutely ridiculous. The Supreme Court did the right thing in overturning the Chevron decision and many other decisions. But the problem is you still have judges on these lower courts that are going to say, you know what? I don't care. I'm not going to uphold the Constitution as it was written and as it should be interpreted. I'm just going to impose my own will and my own beliefs on the people. That's what tyrants and dictators do. We don't need federal court judges doing what tyrants and dictators would do, just imposing their will on the people, abusing and using their power on the bench to oppose their will on the people in clear contradiction and violation of your individual personal rights. It's a very sad day in New Jersey, this decision. Again, I'm Matthew, the average gun owner, and sorry to be the bearer of bad news.